Well, good morning, fellow site members. This is Ken Swimer. I work for Liberty Mutual in Keene, New Hampshire. I'm pleased to facilitate this session today. As many of you know and have attended previous sessions, the idea behind our site virtual roundtable is discuss a topic that is near and dear to us as trainers. So thanks, Sandy, for going over the GoToWebinar features today. We do encourage interactivity, as Sandy suggested, and please take advantage, if you will, on raising your hand or typing a message under the chat area. Sandy and I will keep our eyes on that. So thanks again to Sandy for helping us with the GoToWebMeeting features and advancing the slides and those things. Many of you know Sandy. She's a former site president, and she's been involved in site over many, many years on a variety of committees. Now, Sandy and I were thinking about our fall schedule way back in May or June, and so we put an invitation out or a request for topics for the fall, and lo and behold, Daniel Adams, one of my colleagues here at Liberty Mutual, was the first to respond with the idea of talking about what can we do as far as using intellectual property of others within our classroom sessions. So thank you, Daniel, for coming up with this concept, and Daniel also has recruited another Liberty Mutual colleague of ours, Nancy Brandrud, as well. So we're going to be hearing from Daniel and Nancy today. They've put together a good slide presentation. They'll be stopping every few slides to ask questions, get your input on what they're sharing. And at the end, you're going to see they put together a nice resource of online documents that will help you with this particular subject as well. So again, thank you, Daniel and Nancy, for working on this presentation. I'm going to turn it over to the two of you right now.
Thanks, Ken. We appreciate being here. You know, I certainly do not pretend to be an expert on this subject. I came aboard with training here with my company at the end of May. I had 23 years of experience, most of that in the claims field, and now I found myself in training, and I wanted to make a good impression, and I wanted to wow people with my skills, right, and put in things, put in music, and put in slides, and put in movie clips, and so I happened to be talking with Nancy in the first couple of weeks that I was here, and she kind of educated me a little bit on what we could and might not be able to do. And then I happened to find this article. It's a May 10th article, copyright from the Copyright Clearance Center, Copyright Compliance Awareness of Illegal Sharing Still Lags in the Workplace. So that was an interesting article. But I'm not speaking on behalf of my company, but just a few things that our research brought up during the last few months. So today is a roundtable, so if you have any questions or comments that you'd like to share, please raise your hand or type them in the question box, and we would be glad to entertain those. The more response we get, I think the more valuable it is to get from all of you experts. You know, I don't know that we will get yes or no answers today, but I think what we're going to provide today is more of a guideline in thinking. We start out with the antitrust compliance preamble just to say that, you know, we're going to stay on topic today. We're not going to talk about pricing. We're not going to talk about other insurance companies, but we are going to stay on topic, which is using intellectual property of others in training programs. So, just to get our minds flowing, what are your experiences? What types of issues have you run across? What outside resources do you use when developing training materials? Have you had experience using other people's intellectual property? Did you determine if it was okay to use photos or written materials or show websites or to show movie clips or to share articles? And then, do you have any specific questions? So again, if you have any specific questions, just go to the questions box, send in your questions, and Sandy is looking at those, and we'll bring them up during the course of today. I went out and asked some people that do put out some of their intellectual property items, and I got this response from Ian Brownlee.
It is considered good manners to ask the author for permission to cite their material and ensure that they are given credit for it. As a blogger, writer, and material producer, it really annoys me when I see something that I have written or produced being used by someone else or some other organization without permission, etc. There are times when I actually ask for payment if my material is being used to obtain financial rewards. There are also legal considerations to using music, videos, etc. that seem to vary from country to country. So it is best to check on local laws.
Thanks, Ken, for reading that. So that was Ian Brownlee, a training author, and he allowed us to use his quote here. So we're okay and we're compliant. So here's a true or false. We're going to have 3 questions here, and go ahead and just raise your hand. The first one, everything on the internet is in the public domain and can be used for educational purposes. If you think that is false, raise your hand. If you think it's true, stay quiet.
Well, I would say the hands are still raising, but the greater majority think that is false. Everyone who raised their hand believe it's false. Everything on the internet is in the public domain and can be used for educational purposes.
Well, let's see what the answer is. Oh, look at that. False. Our second question. You don't need to worry about copyright on training that is delivered to employees. So you only have an internal group, an internal audience. If you think that's false, raise your hand.
So this time, I would say about the same number of people are saying it's false. The majority definitely say it's false, that you do need to worry about copyright on training delivered to employees. So,
answer, false. Wow. And let's have our final question here. You can show movie clips in training materials. Gosh, you know, movies are out in the public. Everybody can see them. If it's false, go ahead and raise your hand.
You can buy.
And this is interesting. A lot less people think it's false, but still the majority, I'd say about 50%, well actually maybe 75% now, are saying it's false, that you should not show movie clips or are not supposed to show movie clips in training materials.
And the answer is false. So let's go ahead and get started.
Can we just stop for a second?
Sure.
Andy, do I see Clara? Does she have a question out there? I see a question next to her name.
Yeah, let's, she's asking us to comment on the use of ISO materials. Do you need permission to use ISO materials? How does that work? Maybe others can weigh in the question box as well. And if
let's hold that off to the end.
Mm-hmm. Okay.
Great question, Clara. Thank you. All right, so the agenda for today. So over the next about 30 minutes, we're going to look at what is copyright, what is the legal risk of using someone else's materials, is fair use a reasonable argument? And we're going to talk about, well, what is fair use? What does that term mean? What materials are copyrighted? And then we'll talk about websites and blogs and films and Facebook, YouTube, Hulu, photos, graphics, literary works. And then we'll talk about some resources where you can go to get some answers for your questions. All right, let's go ahead with, let's start out with what is copyright. Copyright covers a bunch of intellectual property, including literary, dramatic, musical, graphic, video creations. It's there to protect the original works of the author. The copyright owner has that right of copying or adapting or transmitting their own content, of giving you permission or not giving you permission of using their work. They can ask for royalties, or they can give it to you as a freebie. But the biggest concern here is that they own that property, and it's up to them whether or not they will give you permission of using it. It's exclusive. Only the owner can authorize the use of that material.
I see that Gretchen has a question out there as well. Sandy, do you see Gretchen's question?
Yeah, she's just commenting that ISO is all copyrighted material. That's the Insurance Services Office, and that's what a lot of insurers use for their forms and policies. So we'll be talking a lot more about ISO in just a little bit.
And so that is something where you become a member, and membership has its privileges, as they used to like to say. Let's do a poll question. What copyright issue concerns you the most? Is it the cost? Is it getting the permissions? How about the legal implications of using copyrighted material? How about the time it takes to get permissions? Or is it really necessary to use in your presentations? So go ahead and select the one that concerns you the most.
I usually try to get about 80 to 90% voting, so when I get there,
so let's do a little countdown from 5, 4, 3, 2, 1.
Okay, we did get to our 90%, so I'm going to share the results. And it looks like most people, 37%, are concerned about the legal implications. Next, 26% are concerned with the time it takes to get permissions. And 16% are concerned about permissions themselves, and then split equally between the cost and necessity. So thanks for
So it looks like a large proportion are concerned about the legal implications, and it looks like a lot of you would like to get permissions, but you know what, it just takes too doggone long time. And so, gee, why even bother? And so I think the interesting question then would be, then do you go ahead and use the stuff without getting permission, or do you just not bother with it and give a vanilla presentation without any of these copyrighted features? So a lot of times it's not a matter of whether or not it's okay or not okay. It might be, what is the risk factor? And these are factors that your attorneys may look at, your own corporate attorneys may look at. Now, I do give you a little bit of a warning, and I would encourage you to find out from your own corporate attorneys what their feelings are. But I think if you have 2 attorneys, you're going to get 2 different answers at least. I know certainly within our company that we have a difference of opinions on when it's okay to use copyrighted material. So here's something the attorneys might consider. Is it an internal or an external presentation? Are you just going to be giving a presentation to employees of the company, or are you expanding outward? Are you giving a presentation to your agents? Is it your captive agents, or are they independent agents? How large is your audience? Is it just a couple of people inside an executive's office, or is it in a meeting hall with several hundred? And again, is it internal, external? And it comes to a trust factor also. If you're meeting with the president of the company, you know that it's staying within their office. How many times will the class be delivered? Is this a one-off, or are you going to repeat this class over the course of several weeks, several months, several years? So what are some other factors that you think that attorneys might want to consider? So go ahead, and if you have a comment or a question, go ahead and use that question box. Again, these factors don't determine whether or not you're legally allowed to use the materials, but they may be evaluated by the attorneys when they provide guidance to you. Do we have any questions or comments, Sandra?
And we don't right now, but one of the things I would be concerned with is the whole virtual, offering it online, having it recorded, putting it in your, for the training materials in your SharePoint, learning management system. We do have a few people weighing in, and I'll share this with you. Gretchen is saying considering is fine, but copyright is protected. Mark is saying, is it discoverable? Very good point. And then Marianne is saying, how do you know if the material is copyrighted? And Evelyn is saying, might it be something that internal employees share with agents? And then Eric is saying, who is the copyright holder?
Yeah, great questions, great questions. And it's certainly, again, if your company or if you happen to be the copyright holder, there's that permission implied anyway. What were some of the other comments?
Considering is fine, but copyright is protected. How do you know if material is copyrighted?
Which I think, and we'll talk about how you know if it's copyrighted, but I think it also comes to, this is a question of ethics. We know right and wrong, and so is this an ethical consideration when you're deliberating about whether or not to use these materials? All right.
Daniel, can I speak to the copyright question?
Yes, thank you.
This is Nancy Brandrud, and a work that you have created, say you're a musician aside from work, and you create a song, you own that copyright automatically. When you're an employee of a company and developing training materials, in most cases your agreement with your company is that the company still owns the materials and you do not hold the copyright. Now these copyright rights are automatically granted to the copyright owner without needing to register them. You can register them. It takes it just one step farther. And again, these are all risk factors that the attorneys may consider just in determining, okay, what is the risk that someone can be in the audience seeing these materials and could bring a lawsuit against the company. And that, of course, is what all companies want to avoid. And so to Sandy's question, when the materials are posted on SharePoint, when it's a recorded session that's made available on, say, for example, this recorded session will be available on the site website, then all of a sudden you're expanding the audience. So you are expanding the increase of risk each time you publish the material in a different location.
And certainly, one of the questions was, is it discoverable? And you may think, well, gee, I just won't put it in my printed material, but I'll talk about it. Well, certainly anybody that was in your audience could be subpoenaed and could be a witness. So you can't hide from it. Let's talk about fair use. Fair use is commonly used for guidelines for researchers, educators, scholars, and others who use copyrighted works without seeking permission or paying royalties. It's not that they have gotten permission, it's just that it's a defense against accusations of copyright violation for people who reasonably believe that their use of copyrighted work was fair use in an educational setting. If you're ever challenged, you need to prove that what you were doing was in an educational setting. So what are the 4 factors to consider when determining fair use? Purpose of the use, including whether the use is commercial or is for nonprofit educational purposes. So certainly, fair use has been applied successfully in the K through 12 arena, elementary, middle school, high school. It has been used successfully in some jurisdictions for college. But you got to remember that college, you're paying for the privilege of going there, right? And so some people may say that that is a commercial endeavor. So there are differing opinions. Nature of the copyrighted work. Again, the age of it, what it is, who wrote it, or who produced it, how long ago, are you using a little bit or a lot? Again, how much of the work will be used? Are you just using a quote? Are you just using a film clip, or are you showing the entire film? Are you using an entire book? Are you using an entire article? Are you giving credit? And the effect of the use upon the potential market for or value of the copyrighted work. And then again, we're giving credit where credit is due. So let's take a look at these items. There's pros and cons. And so, for instance, favoring fair use. You know, I would say, gee, you know, in the training world, I'm teaching. I'm just using it to enhance the training and the education of my participants.
On the other hand, I might argue that if it's being used by a for-profit company, if you're charging your attendees, if the attendees are earning CE credit for attending the training, then it could be construed as commercial activity.
You know, but, you know, I'm just using restricted access. I'm not publishing it. I'm not throwing it out to the general public. It's just for my immediate audience. To, again, help them in understanding the concepts that we are teaching.
But if the training is claims related and you're helping your company reduce losses, then you're actually profiting from the use of that material.
But it's a published work. Anybody can see it. Anybody can get a hold of it. It's out there. I can get it at the library. I can get it at the store. I can get it on YouTube, on Hulu. It's already out there.
And then again, are you citing where you got it? If it's a magazine article, are you referring people to the magazine, or are you providing the entire article? Are you recognizing and giving credit to the person that actually wrote the material? Think about the blogger's opinion quote that Ken read for us earlier.
You know, in this day and age, it's really important that we provide the biggest bang for the buck. And we have participants that are coming to our trainings, and they want to be spoon-fed with the information that they can have. And if they can take something away from the delivery and even share it with others, that's even better. And so if we can make a copy of an article that we've read that underscores the importance of our training concept, that is tremendous, and that is a good use of paper that we can give to our participants and something that they can follow up on and look at after the training is over.
On the other hand, Daniel, is there a possibility that you're impacting the marketability of the original material and you're denying royalties to the author, who should be the individual who's profiting from his creation?
You know, it's not like that I'm giving out magazines to everybody. I'm just copying a few, you know, 10, 12, a dozen, maybe 20, 40 copies of an individual article that I read in a magazine.
How long is the actual article, and what is the proportion of the article that you are reproducing? If it's a large amount, if you're reproducing that in whole, we'll address later different possibilities for obtaining permission to distribute reprints of that article.
maybe I just want to use an idea found in the article. Maybe it's the 7 points of how to be a better trainer, and I just concentrate on one point. It's not like it's the entire article that I'm sharing.
Is the material that you're sharing, though, the core of the material? Is it the key point? Again, how long is the original work? How deeply does it go into each of those 7 points of being a good trainer? These are all of the points that can be taken into consideration and can be argued by attorneys, by courts, and by judges. And they all may come down differently on the fair use. It's a tricky, tricky issue.
Nancy, I sure appreciate you sharing some of your ideas here. This was a good point-counterpoint and a discussion that you could have with your fellow trainers or with your attorneys as you're determining whether or not fair use comes into play on copyrighted material. We go to websites and blogs. These are things that are out in the public. Companies use them because they want people to look at their websites and their blogs. So can you show other companies' websites? What if you show it during class, but it doesn't appear in your training materials? The company's purpose in developing their website is to obtain business for their company and to provide information. They have spent money to develop this website. Each company holds its copyright, and it should not be shown without their permission. Boy, that good old Facebook. I was on it this morning. I was on it last night, and I think the rest of you probably were on it at some point or another. I don't know if any of you saw my comment. Today I declared it National Wear Your San Francisco Giants cap to work day. So if you didn't see that, that's too bad, but I'm wearing my San Francisco Giants hat. Facebook and a lot of the other social medias, they have a statement of rights and responsibilities, and before you went on it, you were supposed to read it, and you checked off that you read it and you understood it. Yeah, right. With several pages, we know that. But one of the things that Facebook says, for instance, is you own all of the content and the information you post on Facebook, and you can control how it is shared through your privacy and application settings. In addition, for content that is covered by intellectual property rights, like photos and videos, in other words, someone else's intellectual property, you specifically give us the following permission subject to your privacy and application settings. You grant us a non-exclusive, transferable, sub-licensable, royalty-free worldwide license to use any of the intellectual property content that you post on or in connection with Facebook. This intellectual property license ends when you delete your intellectual property content or your account unless your content has been shared with others and they have not deleted it. So that's from Facebook's own statement of rights. So things that you post that are yours, you have given Facebook permission to go ahead and use. The question is, what happens when you share things that other people have posted? What happens if I find a film clip on YouTube and I share it on Facebook? Does that give you the automatic right to go ahead and share it also? So one of the things that you need to be concerned with. Tumblr is another site that posts original content that's sent to them. And if you believe that someone's copyright is violated, then a notice needs to be sent to Tumblr, and the material will be taken down. Tumblr, for instance, takes copyright violation very seriously. They don't want to be in trouble, and certainly neither do you. Films, boy, as we were getting this together, we so much wanted to show a film clip, and yet we could not get the permission to show a film clip. Some questions if you want to use it in your training. Can you show an entire film? What if you actually own the DVD? Can you show a clip from the film? And can you show a still photo from the film? So let's just discuss these kind of quickly. But can you show an entire film? And again, that's where that fair use doctrine applies. Now, I have taught college classes in the past. I have used films in the past under the fair use doctrine that happened to coincide with what we were learning. It did happen to be a DVD that I owned, but I don't think that the DVD starts out about the FBI warning and the international warning and all the rest. Just because it's my DVD, I bought it for my own personal viewing. Can you show a clip from the film? Anything from that film, including a still photo from the film, is considered to be copyright infringement. Someone had talked about the use of a poster, and we have gotten advised that you could possibly use a poster in maybe your delivery, as long as it's the full poster. In other words, you didn't get rid of who the producers are and who the director is and all the rest, all that written material on the poster. You take the poster as a whole. You can't just get rid of all that advertising information and just have that picture. YouTube, Hulu, other videos, you know, we see all sorts of things on there. We see clips from TV shows and from music videos. We see videos of live concerts, even ones where you took them yourself, movies and trailers, commercials. Again, all of that is somebody else's intellectual property. The person putting it on YouTube or Hulu runs the risk of copyright infringement. And just because it's already on YouTube or Hulu or any place else doesn't mean that it gives you the open-ended right to use it in for yourself or for training purposes.
I'd like to share a situation that a company ran across, and that is that a well-known international training vendor created some training courses for a company. They were trying to get all sorts of inspirational messages across, and so they used film clips from Braveheart, from Chariots of Fire, from Invictus, all those wonderful, inspiring movies that we've all loved. Their rationale was that it was on YouTube, and they said that it was okay to use them. The company had a really savvy manager who looked at that, realized even though the clips were only 90 seconds in length, they constituted copyright infringement. So the company that had purchased the materials from the training vendor went to their communications department, and the communications department went to the movie studios and obtained blanket permission in order to use those movie clips because they were so critical to the message getting across. And we all know that as trainers. The message is really going to come home with participants if they can identify it, if they can remember that inspiring moment from Chariots of Fire. And so the company obtained the permission, and the cost of doing so was in the thousands of dollars, but the company was protected. And so even though the training vendor, who was a well-known, reputable company, they had mistakenly believed that because it was on YouTube, it was part of the public domain and could be freely used.
We have a quick question from Evelyn. Can you alter, this is going back to your poster example, and she's asking, can you alter the poster in any way, adding text boxes to the actor, etc.?
No, I think that then at that point, and I'd refer you to your own corporate attorney, but I think at that point now you're changing the poster and now you're changing it for your own use. The idea behind the poster is to advertise the movie, and certainly I don't think any producer would fault you for advertising their own movie. But once you've added taglines or conversation boxes or anything like that, now you've changed the content of that poster.
Another point that comes up with changing the original content is parody. We've all run across situations where someone will come up with a jingle that sounds like Dr. Seuss that's applicable in your training situation. Well, there are certain copyright owners such as Disney, the Elvis Estate, Dr. Seuss, that are really stringent about that. And the Dr. Seuss estate has taken people to court for creating parodies of green eggs and ham, for example. So again, it can be a tricky minefield legally.
Thanks, Nancy. All right, so you want to enhance your presentation. Oh, isn't that a good-looking guy there? So you want to enhance your presentation. You want to put in some photos. You want to put in graphics. You want to put in logos. And so where can you get those? Well, certainly your company's photo library, certainly on Microsoft, that you've already bought permission to use that software, which includes graphic arts. You can go to paid sites such as Getty Images or Corbis. You can go to subscription sites. You may have your own personal library of personal photos or personal diagrams that you have created. Certainly you can use that. Or you may just go ahead and get permission from the owner. The reason the picture is there because when we designed this, we got permission from the owner, me. So certainly, and again, some owners are just punched as pleased that you're using their information, that you're using their intellectual property. It certainly increases their status within the community. And so many of them would go ahead and say, yes, please use my article. Yes, please use my quote without a cost. But it goes back to getting that permission. Nancy, I think you had a great example on the use of Getty-owned photos.
I do. We had a situation in our own training department. Now remember, I'm not speaking on behalf of Liberty Mutual, but it is a situation that did come up that many of you might be familiar with. It was a claims training course, and we wanted to show some pictures, photos of water loss. Well, you think you're going to find a lot of water loss photos on Getty? No, Getty specializes in pretty pictures. So our instructional designer went out and checked around the web. All of a sudden found out that there were some great photos that someone had posted of a situation that happened to him, and he was just trying to warn other people of the problems that could happen when pipes get clogged due to roots in the system. And so he had posted all this material just for information, might help other people out. And so our training department reached out to this private individual, because we were able to tell who it was, and obtain permission from him to use the photos in our training material. And we have the written permission, and so we have taken that written permission and included it in the archived information for this particular course, so that we have a record that we have obtained permission.
You know, there are other examples where as people build their own personal websites, or they go into the internet where they think is the public domain, and they see a picture that's just wonderful. Maybe it's a picture of a Montana sunset, or a picture of the Oregon coast or something. Well, whoever took that picture owns the copyright of that picture. And so we had we knew of an example where an agent in building up his own personal website saw a picture on the internet, and he decided, man, that would look great on my site. And so he put it up. Well, the interesting thing was it happened to have been owned by Getty Images. And Getty Images uses a process called spiders, where these spiders go through the web and see if any Getty-owned photos are being used without authorization. And they found him, and they fined him. And the fee was a lot more than had he gone to Getty in the first place and gotten their permission.
Wow. We do have several questions and a couple of comments. Eric, this is going back to the video part. In the instructional designers meeting, we pointed participants to Hans Rosling's 200 Countries, 200 Years, and 4 Minutes, but we did not show the video itself. Is that okay to reference that way?
So they referenced it, but
yeah,
they didn't show it.
They didn't show it. They just pointed participants to the video, but they didn't play the video itself.
Then you're adding it as one of your resources, so it should be okay. You're not actually showing the material, but you are providing the link or the direction so that people can check it out on their own. In that case, again, I'm not an attorney, but I'd say that it was allowed.
And then Eric is also asking, is written permission on paper or is email sufficient?
I think one of the things that you have to, I think email is fine, but can you verify that the email is actually from the copyright owner?
And then this is a comment, Evelyn's saying their carrier requires that if they use photos with any of their employees, they must get the employee's permission to use the photo. And I know our local CPCU chapter, we have a new release form because we like to take pictures of our guest speaker and post them on our Facebook. So we have to get their signature saying that we can use their photo in our newsletter, local newsletter. So that's just a good practice if you're taking photos and get the release of the people who are in the photos. But on the, yeah, go ahead.
That certainly is. It appears awkward, but I know that anytime we've run trainings or we've had events where we've invited vendors or agents, we've done the same thing. Part of it now, it seems like part of the hiring process is you sign a form that allows your company to use your image in their internet or in their publications.
Mm-hmm. And then Eric makes a good point. What about consent for photography from people who may be in the background of the photos that they took in public?
Yeah. How many times have you seen photos go public and they're even on the professional news services, mm-hmm. and people in the background are blocked out? Mm-hmm. So if that's what the professionals are doing, maybe we should take a key from that.
Mm-hmm. All great points. Sandra's asking, what if you use a contractor to develop materials and they are the ones who own the photo?
And the contractor owns the photo. Well, then I think...
Now, if you're paying a...
Go ahead.
In the contract, you're... that the contractor is working under. It's stipulated that the materials are owned by the company because the company is paying the contractor. I would say that it would be good to obtain separate permission like we did with the water loss photos on the internet, obtain some sort of recorded permission either in electronic form, preferably in electronic form, that you can archive with your course materials so that it's very clear that you have permission to use those materials. Good question.
Let's move on. Literary works. What are some examples? Some of this just surprised me. Certainly books, but cartoons, newspapers, journals, magazines and trade journals, emails and letters, memos and newsletters, training materials. Boy, I don't know how often I've used some of these things in training or in Sunday school or with Scouts, but also in professional training. But they are all examples of copyrighted works. So what are some items to consider? Who wrote it? When was it written? And how much of the quoted material are you using? And we've discovered that most works published prior to 1923 are fine to use. we have Shakespeare. But one of the things that we need to consider also is, are you also giving the source of your material? We know that there's a law that says copyrighted work that was created on or after January 1st, 1978 exists from its creation and generally lasts for a term consisting of the life of the author and 70 years after the author's death. So just because they passed away doesn't mean that you have rights to use their material. We're safe here with Shakespeare, certainly. On anonymous works published since 1978, you have to wait 95 years from the publication or 120 years from its creation, whichever is shorter. And then on works published between 1923 and 1977, it's 95 years from the publication date. So certainly things that were used, certainly things that were written in the 1800s or the 1700s, gee, if it applies, if you can find something that applies, you can certainly quote it. But more recent works in the 20th and especially the 21st century, you need to get permission. Music, music is wonderful, and we talked about like Chariots of Fire. You hear that song and you're inspired. You know where it comes from. But factors to consider: who wrote it, when was it written, how much of the quoted material are you using? You notice here that we're using just a line from a recent song. We're not showing the person who wrote it or sings it. We're not using the melody in this presentation. Probably just a short clip is okay. How many of you use games in your training? And how many of you use the Jeopardy type game or the Family Feud type game in your training? And do you call it that, the Jeopardy type game, or do you call it Jeopardy? There may be a concern there. There are intellectual rights to that game. How often do you, when you're playing that, you have the little song that goes along with it? Again, these are copyrighted items. As we look at books, again, the questions to consider: who wrote it, when was it written, how much of the original material are you using? Don't you love Stephen R. Covey? Now, and again, this is a perfect example of here we're using a small quote, here we're giving the author credit, but it's not something where we could be giving out his book as part of our training material, even though Stephen R. Covey just recently passed away. Okay, so let's look at some steps in protecting yourself and your company. We know this. Cite all your sources, and there's the right way to do it and the wrong way to do it, and Strunk and White, the Elements of Style, can give you that. But certainly the author's name, where you got it, where it's from. Be familiar with the copyright information on your own company's website. You certainly can subscribe to someone like the Copyright Clearance Center. You can subscribe generally, or you can subscribe for a specific piece of material. Go directly to the copyright owner and request permission. That's probably the best bet for you. Do your due diligence. Check out the legal page on copyrighted policies. Obtain reprints from a publication's websites as they allow you to do so. Let's give you some resources. YouTube, for instance, if you go to YouTube on their Copyright Center, they talk to you about they give you some information for copyright education. So I would go ahead and go to this resource and just take a look at what they say about what is and what is not copyrighted. You may want to go ahead and use that perfect article from a trade magazine. And, you know, we have L&D, or we have Claims, or we have Training Magazine. There are some great articles that we would like to share with our peers, and there's probably some great articles also that we would like to use as part of our training as we go and train underwriters or agents or claims people. Here's an example of using this request form and just asking to use it and letting them know what you're using it for. So here's a variety of resources that we've used in development for today. Certainly go to your own company's legal department and find out what is their attitude on copyright and the use of copyrighted material. What do they already have in your own library to use? The Copyright Clearance Center. There was a small little video. It's more of a commercial than anything else, but it's about a minute and a half that you may want to go and take a look at, telling you about the Copyright Clearance Center. The Digital Millennium Copyright Act of 1998, YouTube's own Copy Center, websites about us or legal page. Check out Facebook's, and we read a little bit about that. Certainly the United States Patent and Trademark Office if you want to delve into the meat of it. Columbia University's Fair Use Checklist. Again, is this for teaching purposes? Again, the K through 12 is pretty clear. Going into college gets a little muddled. Going into the type of training that we do gets even muddier. And again, different people will give you different answers. Different attorneys at your own company may give you different answers. Some will say training is teaching and it's therefore okay to use. Others will say, however, if we're charging for it, maybe it's not fair use. When in doubt, refer to your legal department or don't use it at all. All right, so that gives us just a couple of minutes for any questions or comments that any of you would like to bring up.
Okay, and we do, go ahead and raise your hand if you'd like to be unmuted. So we have Gretchen, and we'll unmute you in just a moment, Gretchen. And she's making a comment in the chat as well. Clearance Center may only give permission for a certain type of use. They may grant permission to quote or print for personal use, but not printing for handing out during training. Oh, that's a good point.
Gretchen's bringing up a really good point about the Copyright Clearance Center, because in our own situation, Liberty Mutual does subscribe. However, we do not subscribe to the movie rights. It's only for the print versions. And the other decision that we have heard from our corporate attorneys is that it's only for internal use, to be shown to our own employees. So even though you can obtain rights on the Copyright Clearance Center to maybe show a cover from Time Magazine, for example, it can't be used in agent-facing courses. So again, it gets to the question of, is it an internal or an external audience?
And let me go ahead and go ahead.
And it may also go to the point of how often are you using it internally? Is this something that you're going to use for every new hire, for instance, or is this for a one-time meeting?
And we do want to make sure that we circle back to the question on ISO, and Bill Wilson has a comment regarding that I'll share out to the group. And I'll unmute Gretchen first, and then Jim also has his hand raised, so we'll listen to Jim after Gretchen. So Gretchen, you're with us now. How are you?
Fine, thanks. I just wanted to mention that on that Copyright Clearance Center, if what you're looking for to be able to use isn't there, you can still go to whoever owns that property. And I've done this, and so I find an article in a magazine and they say, well, yeah, but it's not our article, you got to contact the author. So they get me in touch with the author, and about 4 or 5 emails this is going to take for me to actually get permission to use the material. But if I really want to use that material, I will go to those steps to get the appropriate authorization to use it. I have an email file folder full of various permissions that I've gotten from people. Some have said point blank, you can talk about this article all you want, but you cannot print it.
Mm-hmm.
Okay. So it depends on who you're dealing with, but just use caution. Just because something's coming through your Copyright Clearance Center doesn't mean you have necessarily completely full reign.
Mm-hmm.
So.
Yep. Great. Let me go ahead and get Jim to join us as well. And Gretchen, I'm going to leave you unmuted, so if you want to make any additional comments. So Jim, you're with us now. How are you?
Hey, I'm fine. Hi. I want to say hi to Evelyn, my friend Evelyn. I haven't talked to her in a while. But, you know, here's a little story, and it just pays to use caution, even when you think you're taking some of the right steps. You know, we were preparing an auto-physical damage training piece. And a couple of my trainers, they are instructors for ICAR. And, you know, in doing this, one of their field reps said, oh, yeah, you can use these materials. And I'm thinking, wow, you know, I'm not quite certain. And thank God I was, because brought it up with one of our lawyers here. And then we contacted one of the people, the executives at ICAR, to say, hey, this is what we're interested in using these shots of. And no, we really weren't able, and what their field rep had said was not true, that we did not have the permission. And you know, it turns out that we made arrangements to get to use what we wanted, but the thing that you have to consider, some of the stuff that they use is not of their own origination. You know, they may have paid for rights from somebody else, and that seemed to be the case in some few of the things we had. So it really goes deep, and you almost have to kind of be suspect of anything that's out there to think you have free reign to go ahead and use it. You almost have to really do due diligence and check on it.
Mm-hmm.
Jim, thank you for that. This is Ken. We do like to keep the situation or our program to an hour, so I'm going to take a moment at this time to thank Daniel and Nancy for helping us out. You do see on the screen our next session is scheduled November 30th. This session will be out on our website, and feel free to follow up with us if anyone has any additional comments and questions. And again, thanks Daniel and Nancy for sharing this information, but more importantly, letting us know what resources are out there. So we'll end our session for today, and thanks everyone for